Of course, you're a judge because people can't get along either. So, all right. How are we doing on attendance, staff?
I am showing 7 of our 15 members are here, so we're just shy of quorum. I believe we need 8, would be over half, but we're not quite there yet.
Okay, but we're getting there, so good. Judge Williford, are you ready to start?
I am whenever you are.
Okay.
Recording in progress.
Thank you. All right, so good morning and welcome. I'll remind everyone that public comments are only taken at the Child Support Commission meetings, not at these subcommittee meetings. Though if you have something burning that you feel like you need to address to this subcommittee, we'd be more than happy to entertain putting you on the agenda if you'll just email staff in advance of our meetings so that we can discuss it and make sure it's germane to the subjects that this committee is intended to review. Sometimes we get people addressing the wrong committee, and if you are addressing the wrong committee, we'd be happy to point you in the right direction. Latana, do you want to give us a reminder on the meeting rules and membership, please?
Yes. Just piggyback off of Katie. Good morning, everyone. I'm just here to review a few rules to help us navigate this meeting via Zoom today. This meeting, the Statute Review Committee members and staff are panelists and can speak anytime during the meeting. All others are considered attendees and are muted during this meeting. We will not take public comments today. Okay, what Katie had stated. And I'll roll it back over to you, Katie.
Thank you, Latana. And Latana, I'm counting on you to take attendance for us.
Yes.
Thank you. Okay, the first agenda item we have is the meeting minutes from the July 15th meeting. Those have been circulated, and hopefully those of you who were in attendance have had an opportunity to review the minutes. Do we have any proposed revisions to the July 15th meeting minutes? Has anyone who was there and therefore eligible to vote on them not had a chance to review them? Should we give everybody a minute, or can I get a motion? Well, I guess we need our 8th person. So we'll move that to the bottom of the agenda. So if you haven't had a chance to review them, please go ahead and take the time to do that, because hopefully before we adjourn this meeting, we'll get our quorum so that we can entertain a motion to approve the July 15th minutes. Pat, go ahead.
I wasn't at that meeting. I wasn't a member of the committee yet, so I can't vote.
Right.
Yeah.
So
Yeah.
you actually need
Two more members.
Good point, Pat. And actually, speaking of that, Pat, welcome. Not your first rodeo with Statute Review Committee, but thank you. We're glad to have you on the committee. For those who don't know Pat, I think most of you do. I'm looking at faces, but maybe not. Pat used to be, let's see, Noelle is the new Pat, or Pat is the old Noelle, depending on how we want to look at it. Pat used to have the role of staff counsel for the commission, and therefore in that capacity sat in on many a statute review committee meeting. So she wasn't a voting member at that time. She was commission staff. She is now a voting member of this subcommittee, and she also was on the Parenting Time Deviation Study Committee, which we really still need a catchier name for that. I will tell you, I'm listening to a biography on Andrew Jackson right now. Well, I'm doing all the presidents, but I'm on Andrew Jackson, president number 7. And so I'm listening to a lot about his relationship with the Native Americans. And so it makes me think that our Parenting Time Deviation Study Committee needs a name like, committee that felt it would never end, or, because the Native Americans like to name things after, descriptions. So that's where my brain goes right now because of, what I'm digesting. So we could come up with a catchy name for that committee, like, the never ending committee, the committee with no sunset, something like that. That's where my head is these days. Anyway, Pat, welcome to the Statute Review Committee as a member. Though, as I said, you've sat in on many Statute Review Committee meetings. So thank you for being here, and thank you for your time. That goes to everyone. I don't think there's nope. In fact, I'm sure there's not a person on this committee who doesn't have a day job. This is all volunteer work for the betterment of our state, our community, and the citizens of Georgia. So thanks to everyone for being here, and welcome, Pat. We're glad to have you. Okay, I'm going to turn it over to Judge Williford, my co-chair, because the next item on the agenda is the parenting time deviation.
Good morning. I am at home quarantining from COVID, and I'm still a little bit weak in my voice, so forgive me for that, but I'm feeling much better. And I am fairly new to the commission. I don't know, Elaine, how long have I been on it? Maybe a year or so, but I'm certainly new to this process. And so I'm learning that I was asked to co-chair the Statute Review Subcommittee, and especially as it relates to the parenting time issue, because Katie was chairing the Parenting Time Study Committee. It was felt necessary to maybe put me in charge of the parenting time deviation part of the Statute Review Subcommittee. And first, let me just say that this group that I was not a part of, this Parenting Time Study Committee, for those of you who don't know, Katie's not exaggerating, it was a Herculean effort, I think, on the part of these individuals who met at least 22 times, I think, for many, many, many hours, and put a heck of a lot of time, energy, and effort into that, all on a volunteer basis, and did a fine job coming up with a very clear list of issues, which is first and foremost important is what is the problem, and what all do we need to consider. And we're able to reach a consensus on a lot of those things, but not all of those things. And I don't know who all has had an opportunity to review the end report on that parenting time study, but you can see that they put a tremendous amount of work into it and gave us a lot of information and a lot to think about. Not only what the issues are, but how, the other states are handling those issues. And for a lot of those issues, the recommendations. From that study, the staff and I met and came up with a task list. And I don't know, was that task list, was that circulated out with the agenda?
No, it wasn't. If you want to, I can pull that up.
Yeah, if you could,
saw that as a primer for you, as like a welcome, really.
Yeah. And so we'll get back to that in a minute, Noelle. I see that Regina Quick has joined us now. And
oh, yes, she's on.
Okay, I'm sorry, Regina, I didn't see you earlier. The agenda notice that I have starts with asking Regina to talk about her suggestion of a resolution for Legislative Study Committee on parenting time. So Regina, can I kick it to you and you tell us about that discussion that you had with the staff?
Certainly, and thank you very much, Judge Williford, and to members of the committee, and to co-chair Connell. This sort of revives a discussion that she and I had between last year's legislative session about study committees and their role in educating the legislature about complicated issues. And so what a study committee permits you to do is several things. One is to find some champions in the legislature that you can count on, so that staff is not, and this commission is not, just rolling a piece of legislation into the hopper being carried by a member of the commission, but rather identifying some folks that have some passion and will be advocates for these positions and these discussions. But also it hedges your bets. If your legislation is too complicated to obtain passage, then at a minimum, you hope to be able to persuade people that it's important enough to have a study committee so that legislators can take a deeper dive in the periods between one session and another in a 2-year biennium to make sure that something's happening toward resolving problems and dealing with issues and concerns that have been raised in the interim. If you look at the schedule of the General Assembly right now, you'll see a solid 2 or 3 months already on the schedule of study committees, and study committees have been meeting on various topics for the last month through the month of July. So it was my thought that with all this good work that the Parenting Time study committee itself has done on this, that it would be a shame not to try to maximize your ability to educate and get the best possible product and no unintended consequences with the legislature. And so that's, I think, particularly true with this area of subject. When you look at 2 pages of items of consensus and 7 pages of items with no consensus after those 22 meetings among expert lawyers, and then trying to have those discussions with legislators, the minority of whom are lawyers and are likely to have no expertise. I think you may find yourself in a situation where you need an educational process with legislators. So to that end, I brought this up to staff, and I'm happy to help. I'm happy to answer any questions anybody might have about that process. I don't want to undermine anything anybody's done, but this is also gives you 2 avenues for success. Let me just put it that way. That's probably the best way to put it. And I again want to thank the chair of this this study committee, the committee that wouldn't end, or whatever she just said about this, for her service in this and her service to Georgia's families. Historically speaking, nobody may know she was the first practitioner ever appointed to the Child Support Commission. So she is a historical figure in and of herself, and many people worked tirelessly to finally get a practitioner on the commission. And so it has made all the difference, and her service has made all the difference. So thank you, Judge, for the opportunity to speak on this topic.
Well, thank you, Regina. And I may actually kick it back to you after I go over the things that I'm going to go over, because what I'd like to know after I say what I say, and maybe some other folks chime in, is whether or not you think we're ready to do that, or based on what I say, whether or not you think we need to wait a little while on that. So I may actually kick it back to you. It is nice to, and I will tell you, I don't know a lot of you, and I did have to get online and research some of you and see what I could find about some of you. But I certainly know that Regina has a background in family law, and Katie does too. And for those of you who don't know, that was primarily what my practice was for 20 years before I was a judge. And so these issues to folks who did not live, eat, and breathe it every day may seem very, very complicated. I understand that. And I was sort of hoping that our senators on our subcommittee would be on here, but I don't see them yet. But these are things that if you don't do this every day, you may be confused by it. And so I'm going to sort of back up a minute and just say, and the number one thing that we had on our task list was, does the parenting time deviation in Georgia's child support guidelines statute need to be amended to better meet the needs of Georgia's families? And for those of you who don't know, and maybe you all do know, that the statute that basically tells the Child Support Commission what we're supposed to do, 19653, at A13 says that the commission shall study the impact of having parenting time serve as a deviation to the presumptive amount of child support and make recommendations concerning the utilization of the parenting time adjustment. So the stuff that Katie and her group have been working on for the last 4 years are things that they were required to work on under the statute. And like I said, it was a Herculean task. And at the end of the day, they were able to get a lot of good work done, but still at the end of the day, and this is no insult to them, we're not able to say, all right, here's what we need to do. Okay. They were not able to reach a consensus on a lot of the things. What we need to do it, but how we do it, I guess, was one of the big issues. And so we came up with this task list of things that we think still need to be addressed. And Noelle, if you or someone could share that screen, I'll quickly try to go through it. And like I said, I met with the staff for several hours. And I know that you all know that our staff really are the foremost experts, I think, in the state on child support. So I certainly appreciated their time and going over these things with them. And it kind of goes back to what Regina said. We had this group of very, very brilliant people who do this and know this and eat, sleep, and breathe this, that after 22 meetings and many, many, many hours, we're not able to reach a consensus on several things. So when it sort of got kicked to me as co-chair, I said, well, if Katie Connell couldn't do it, I can't do it. I can tell you that. So it kind of came down to, so now what do we do? Okay. And I think after we all talked for a while, it was determined that, we could meet another 22 times and another 1,000 hours, and we may run into the same problem, that we really need some guidance, maybe some, I live in a kennel, by the way. Hold on. I'm so sorry. Give me 1 second. Like I said, I'm at home. My husband and I do a tremendous amount of animal rescue. And I'll tell you that we are both on the boards of several animal rescue groups, and we are foster failures because we bring them home and we end up with them. So we have a house full. But getting back to that, maybe we need an expert who can say, okay, you've come up with this. This is what you've decided you needed to do, and it needs to happen. And this is how you ought to do it. And I don't think there's a better expert, based on what I've been told, than Dr. Venor, who helps us with the economic subcommittee and the calculator and all of those issues. And so the question became, could we contract with Dr. Venor to help us with this issue? When I say help us, literally be a part of this subcommittee and help us figure out, okay, this is what you should do and this is how you should do it. And so I asked Elaine to find out if that is something that Dr. Venor could do, would be interested in helping us with. I mean, she may just say, no, I've got my hands full with all of this other stuff that I'm doing for all of these other states, and there's no way I could do it. But whether or not she could, and whether or not we would have the funding for that. And that way we could actually hone in on all the good work that Katie and her group have done and share with Dr. Venor, okay, this is what we're down to, and this is what they've reached a consensus on, and this is what we feel like we want to do, if that's what we want to do. And all right, how do we get there? Help guide us so we don't go down any rabbit holes, or we don't get, off task, and we really need to get this done. I don't know that, when they worked on it for 4 years and couldn't come to a consensus on everything, if there's any hope that we're going to be ready to give anything to the legislature in the upcoming session. I can speak for myself in saying that if this were my full-time job, I don't think we would have it ready for the legislature. And certainly it is not my full-time job. So I do think that it's going to take more time, and it may be that our goal would be not this coming legislative session, but the 2024 2024 legislative session that we might actually be ready to present something. And, but I want to go through quickly this task list. We talked about number one, which is that the code section requires us to do this, to at least look at it and make recommendations, which I think is what Katie has been doing. And number two, for anyone who's not aware of it, there's certainly no guidance in the parenting time deviation as to how to calculate the amount of that deviation. As a practitioner, that was frustrating. As a judge, that's frustrating. And if you are a family law practitioner and you go to the seminar every year, there are always a group of judge panelists there, and you'll kick this question out to them: how do you handle the parenting time deviation? And they will all give you a different answer. You know, how do you do shared parenting time? How do you do joint custody? What kind of deviation do you give? What kind of formula do you use? They'll all give you a different answer. And so there's no good. And in speaking to the staff, when they have these training sessions, they're often asked, well, what formula do you use for the parenting time deviation? Or how do you do the shared parenting? Do you, cut it in half? Do you net it out? What do you do? And they can't really give them an answer. And they're the ones that are teaching this thing, and they can't give them an answer. So we have this very thorough, very lengthy statute that's been in effect since 2005, was it? January?
2007, January 1st.
2007, okay. It seems like it was 2005. I think that's when y'all started working on it, right?
That's true.
Because for a couple of years as practitioners, we were told it was changing, but then the date just kept getting put out. And now that I'm on the commission, I certainly understand why. But so, for all this time, we've had this very lengthy statute, and yet we've never been able to get any real guidance on how this deviation works. And of course, most of y'all know too that Schedule C was supposed to be the parenting time adjustment schedule. And because it didn't pass, and it was such a complex issue and still remains such a complex issue, then that schedule was reserved, and it's still reserved, so there's no guidance, and we need some guidance. And I think everybody can agree that we have to fix that. There has to be some guidance. The basic child support obligation table, there's no accounting for parenting time in that. And, we talked at length the other day when we met, I met with the staff about this issue. So as a practitioner and now as a judge, it would be very, very rare for me to have a family where one parent had 100% of the parenting time and the other parent had none. Okay. So the overwhelming majority, there was going to be what we term, and a lot of practitioners will refer to as standard. And so standard may vary depending on what circuit you practice in, but there would be something that all practitioners who did family law in that circuit were used to, whether it was every other weekend and half the summer and half the holidays, or a Tuesday overnight, or whatever it was. That if I were speaking to Katie Connell and she and I had a case together, and I would say, well, how about joint legal with my client having primary physical and your client having standard visitation? Katie would have some idea based on what circuit the case was in, of what I was offering, without me having to say, dad's going to get Friday after school to Monday return to school or whatever. And I think every practitioner in family law has an idea in their mind of what standard parenting time for the non-custodial parent looks like. And so a large majority of them are that. We are seeing as older judges leave the bench and younger judges take the bench, and just sort of a shift in some mentality. I think we are seeing more joint physical custody cases than we ever saw in the past as well. Because there was a old school mentality for a long time that, you know, babies go with mamas and, you know, daddies get visitation. And that has sort of evolved over the years too. And for other reasons as well, we're seeing more joint physical custody. But there's nothing in the basic child support obligation table to account for any of that. So now if you look at your chart and you see, all right, this is the presumptive amount mom should be contributing, this presumption amount dad should be contributing, it really accounts for one parent having all the time and one parent having no time whatsoever. So I threw out there, doesn't it make sense for us to talk to Dr. Venor about having some sort of threshold in the BCSO where it's like a 75-25 or something like that. And then if it needs an adjustment, you adjust from there, because otherwise you're going to be adjusting on almost every single case, except for the rare situation where one parent has, you know, all the parenting time and the other parent has nothing. And they were smart enough to bring out to me, and this sort of jumps us down to number 9. But if you fixed it on that end, then you've created a huge problem for DCSS. So child support services are not willing to, and I'm not blaming them, because this would really be a Herculean task on their part, to have these hearings about parenting time, okay? But even if they were, the bigger problem might be that for a lot of the cases, probably an overwhelming majority of the cases that DCSS sees, we are not talking about children who have been legitimated. So we're talking about children who are born out of wedlock, who were never legitimated. And so under the current law in the state of Georgia, that parent has no legal rights. They have no custody rights. They have no parenting time rights unless and until they file for it and a court order allows it. So for every one of their cases, even the ones who get up there, and we see this as judges all the time, we have DCSS in front of us, and you have the litigants in front of you, and they will say, yeah, well, I shouldn't have to pay this amount of child support, judge. I have the children half the time, or I have them more than she does, or whatever, even though there's no court order allowing it. And so that's why number 9 is on here. Should a parenting time adjustment deviation be based only on court ordered parenting time? And what that means is, can we give a parenting time adjustment or deviation to someone who under the law has no legal rights to parenting time or custody? And so if we were to build that into the BCSO, if we were to have Dr. Venor consider that and build in a 75-25 or 80-20 or a 60-40 or whatever, and then say, this is going to be the norm. This is what we're seeing mostly in the state. And then if it doesn't fall into this sort of, average scenario, then do we go to the adjustment or the deviation? But if we did that, we would be unfairly adjusting it for the folks who have no legal rights to parenting time or custody. And that would create a big problem for DCSS. And in having this conversation, I said, Georgia has got to fix this legitimation problem. And no, that's not part of the statute review subcommittee or the child support commission, but it really all ties into each other. It's part and parcel of each other, because in order to fix this parenting time problem the best way that would be fair to all, you need to fix this legitimation issue. And I believe that Georgia is one of 2 or 3 states who still has this very antiquated legitimation statute. And so again, I was hoping that our senators would be on here, but the question then became, who would we reach out to, or with the family law section? And I know, Katie, you were involved in the family law section, and I know some of the rest of you may be. Who on that, in that area, if anyone, is working on this issue, or is this issue now dead? I know we tried it many years ago. Regina, I don't know if that was when you were in the legislature, but the administrative legitimation that really didn't solve the problem, and certainly created a lot of confusion, and still did not give anybody any parenting time or custody rights. So you could administratively legitimate, and so what? That meant you were the legal father, but you had no rights. You had very limited rights. You might have the right to inherit or so forth, but you didn't have any custody or parenting time rights. Unlike states who say once you've legitimated, you then sort of stand in the shoes of the father who would if they were married to the mother, and that sort of thing. And I know a lot of states do that. And it's a complicated issue. I understand that the adoption rights folks are really against it. And there's been some pushback there. But if we don't fix this very antiquated legitimation problem, then I don't know how we're ever going to fairly come up with a good way to fix this parenting time problem. So that may seem a little bit off topic, but I wanted to know if anybody had any suggestions about who might be working on that issue, or how we could sort of get that issue back on the radar of the family law folks, and have maybe a legislative study committee once again on that issue, so that could be addressed.
Judge, I don't want to monopolize what everybody else has to say, so I'll listen for just a minute. But I will tell you that what you've just brought up could be an aspect of the same parenting time study committee. It doesn't have to say parenting time adjustment only. It can just say parenting time, and that, I think you've highlighted that it is intertwined. The administrative legitimation statute was a terrible thing for judges and created all sorts of problems, and the juvenile court judges and others, I think, assisted in the administrative repeal 5 years ago or so, if memory serves me. Might have been 2017, might have been, it was earlier than that.
I think it was 2014 or 15, if I'm not mistaken. Yeah.
So that's been gone for a while, and so I do think you bring up a good point that may explain why the presumptive amount of child support did not include any parenting time to begin with when the statute was enacted and effective in 2007. But I will make this point before I listen to everybody else who wants to talk. At a minimum, even if it remains the same, the one thing that this subcommittee could recommend to the full commission is that the statute be amended to clarify for judges and others that the presumptive amount of child support and the BCSO does include 0 parenting time, so that everyone is clear, because the statute is not perhaps as clear. Well, it's not clear at all on this point. I think that Katie's committee pointed this out adequately and wrestled with this, and has highlighted a glaring problem that there may have been those that understood it and maybe others not so much.
Well, Regina, that you're exactly right, because as a family law practitioner for many years and now a judge, I didn't know that. And I was embarrassed to admit that, but I think it's important for me to admit that, because if I didn't know it, then I can suspect that there are many, many others who didn't know it, because somewhere back in history, I had been told, and then I believed it without having any evidence of it, that there was time built in to the presumptive amount. And I would tell my clients that, oh, this assumes that you get about 100 days. You know, I would tell them that. Now, here's the problem, and this is a big problem, is that once we educate everybody to that, and I think you're right, they need to be educated that, then the right thing to do then would be for judges to start saying, okay, well, this person gets 100 days out of the year, I need to deviate, right? Or at least I would have, as a practitioner, I would have argued that more to judges. I would have said, Judge, I don't know if you're aware, but these presumptive amounts assume that mom or dad or whoever it is who's the custodial parent gets 100% of the time. And here's our parenting time schedule. And I can tell you that's not the truth. So we're asking that you deviate this by $200 or whatever. Okay. Now, I never did that, but that's certainly what I would be doing if I were practicing law today. And as a judge, I think, well, I need to be looking at this when I'm ordering child support. That means that judges would be deviating for, again, almost every case. Okay. Maybe not DCSS, but everybody else. And then guess what's going to happen? Our deviation rates are going to go up, which is another problem that we have that people might not be aware of, is that the federal government audits us and looks to see what our deviation rate is. And if our deviation rate is too high, then we get in trouble and we have to have a corrective plan and we have to fix it. And if we don't, we lose federal funding. Okay. And that brings us back to why it has to be an adjustment and not a deviation. Because if we're going to deviate at 40%, or I think, you know, at one point we were as high as what, 45% or so, right, Elaine?
Yes, correct.
Those are unacceptable numbers. When they audited, you know, ever how many judges or circuits or counties that they audited and saw that we had a 45% deviation rate, that's unacceptable. Okay. And so what they're basically saying is if you've got a 45% deviation rate, your chart is off. Your basic child support obligation is off. Your numbers are completely out of whack, or judges wouldn't have to be deviating at a rate of 45%, or practitioners or whoever it is, right? So the bottom line is we have to fix it. And my brilliant idea and others and the teams too, the study considered all this, is, oh, well, let's just fix the BCSO, right? But you can't, because of the legitimation problem and the DCSS problem, you know? So that brings us then to number 4. Should the parenting time deviation be changed in the statute to a parenting time adjustment? And I think the study committee said, yes, that's what should happen. And I agree that that's what should happen. Initially, when I was asked to be a part of this, I was just like, no, Katie, I don't want to be a part of this because I don't agree with your study, and judges should have discretion, and this should be a deviation and not an adjustment. But now that I'm educated about the problem with the federal government and the funding and the deviation rates that they look at, then I'm like, okay, yeah, that's compelling. That's a very compelling reason that this has to be an adjustment. Okay. But I also know this as a practitioner and as a judge and as someone who has been involved in access to justice for the many rural counties who have so many people that represent themselves. And we see a lot, you know, I'm in Peach County now, and I see so many self-represented litigants in family law cases. And, you know, we can't make it overly complicated. And if we make it overly complicated, it's not going to work. And I appreciate what the study committee said when they said the simplest way may not be in the best interest of the children. And I get that. But I can tell you, if it's not simple, it's not going to work. If it's not simple, it's not going to work. And if it's not going to work, don't have it, because it's just, you know, the self-employment calculator. All the fancy, smart, brilliant, rich Atlanta lawyers may use it. Nobody else in the state does. I'm just going to tell you, they don't. They don't know how to use it. They don't know what numbers to put in it. They don't know how to get the numbers to put in it. They don't use it. Okay. So when we start talking about this complicated calculator that you've got to move to, and you got to figure out what has the parenting time schedule been for the last 2 years, and you have a hearing for 5 days, and one person says, I've had them just as much as mama has, and the other person says, he might get them 1 weekend out of the month if we're lucky. And you're trying to figure out which one is telling the truth. Nobody's going to agree on what the schedule has been for the last 24 months. So it's not as simple as just plugging it in there. So if you say, well, we're just going to go by the parenting time plan, the court-ordered schedule, and put that in there, well, how is that in the best interest of children? Because any good practitioner is telling folks, put this parenting schedule in a drawer and don't look at it. Do what's best for your children. Work with their schedule and your schedule and everybody else's schedule, and co-parent, and don't worry about what this piece of paper says. But if we're going to tie it to this schedule, and if we deviate from that schedule, somebody's going to lose money and somebody's going to have to pay more money, we're going to have a problem, you know? So it is a very, very complicated issue, because on the one hand, you want to be fair to folks who are having to pay child support. You want to be fair to people who are receiving child support, but most importantly, you want to do what's best for the children, which is a mom and dad, or mom and mom, or dad and dad, whatever it is, that can co-parent and do what's best for the children, regardless of the money. And so taking all that into consideration, with the problem that we have with the fact that the current BCSO accounts for no parenting time, and that DCSS cannot and will not get involved in 3 and 4 and 5 and 10-day hearings on what the parenting time schedule is or has been. And can they, if dad has not legitimated and under the law has no legal rights, even if mom is letting them see the child, okay? And you look at all that and you think, how in the world are we going to fix it? And that's before we even get to what is a unit of time and all of that stuff. And that's why I think it's important to get somebody like Dr. Venor on board, who can help us really get down, you know, because we can meet another 22 times and we can talk about another 100 hours. But we need somebody to say, okay, here's the deal. We've got a problem. We know this isn't how it works. We know one person doesn't have all the time and the other person doesn't have any. Legislator, we need to fix this legitimation issue. It's a much bigger issue than y'all realize, because it's also an issue for our Child Support Commission. And we have no guidance on how to deal with this deviation. And it really does need to be an adjustment, because our deviation rate is too high and we're going to lose money. With the legislature understands that more than anything. Got to please the feds or you lose money. Okay. I know, I don't know a lot about the legislature, but I know that they understand that. Okay. And so if we get all this together, and we present that to Dr. Venor, then maybe Dr. Venor can give us some pretty strict, strong guidance and help. And all right, here's a plan. Why don't y'all present this plan to your statute review subcommittee and see what they think about it? You know, and then maybe a legislative subcommittee, study committee as well. And I don't know which one comes first. Do we see if we can hire Dr. Venor or somebody like Dr. Venor to help us come up with a plan to present, and then that work in at the same time the legislative study committee is working on a plan? Or do we do the legislative study committee and see what they come up with and then decide if we want to hire somebody? I'm so new to it, I don't know how it works, but I feel like we've got to have we're not ready as a statute review subcommittee to now say, okay, Katie tried for 4 years. And these are all the things they couldn't agree on. Now let's us as a subcommittee meet and agree on it. I don't think that's how it's going to work.
Judge Williford, I can add that we have already affirmatively asked Dr. Venor to address these issues as part of the 2022 economic study. And
Oh, that's a good point. Why don't you pull our contract up with Dr. Venor and let's talk about that?
Sure thing.
Because we talked about that the other day. We have a contract with Dr. Venor that ends at the end of September of this year, and we haven't gotten the report yet. But number 14 and number 15 on this contract, 14 says contractor will opine as to whether accounting for parenting time, including shared parenting, 50-50 joint physical custody, should continue to be handled as a deviation. And number 15, contractor will give a recommendation as to the best way for Georgia to account for parenting time in child support calculations. So we have these sort of broad directives to Dr. Venor in the contract that we currently have with her, and we have not gotten a report yet. And when do we expect that report?
Okay, we're gonna get a tentative report from her at the Child Support Commission meeting on the 19th of August.
So next Friday.
That next Friday, and then on the 30th of September, she'll have us the final report with recommendations.
So we really need to see what's in that report or those reports. You know, did she just, you know, is it included? Hopefully it is. Is it an in-depth, you know, or is it just a broad, you know, opinion on that? I don't want to speculate, but, you know, if I had to guess, it's probably not nearly as in-depth as we need it to be based on our task list here. We have 9 things on our task list, and we were talking the other day. We said, you know, this is a very broad 9 things. If you really broke each one of these things down, you could put dozens of subcategories within each of these 9 things on the task list. So I'd be surprised if Dr. Venor's report is going to sort of address all of these issues that we have, but it would be nice to know what she does say in regards to number 14 and number 15, and then go from there. But I know I've said a lot. Let me hear comments and concerns from folks before we go any further on this task list. All of it is really from there. It's, you know, if yes, what would the unit of time be? And should there be a threshold amount of parenting time before any discretion? So again, does it start with you get an adjustment or you get a deviation from day 1, or is it day 10, or is it day 20, or day 90, or day 100, or what is it? Again, I think Dr. Venor could weigh in on that. Should a parenting time adjustment / deviation be presumptive, rebuttable, and or discretionary? As a judge, I can say I think it's of paramount importance that judges have discretion outside of anything that we come up with, because there's just no way for any statute to account for every single variable that could be going on within a family, within a parenting time schedule, in the best interest of children. So at the end of the day, judges always need to have discretion. And then consider how a parenting time adjustment deviation will work in cases with joint physical custody, shared parenting, split parenting. We've talked about that. We certainly need more guidance on what that formula looks like. And then we've already hit on number 9, which is the problem we have with whether or not it just needs to be for court-ordered parenting time. Because does a judge have the right to give a parenting time adjustment to someone who under the law does not have any legal or custodial rights because they've not legitimated and obtained those? So let me hear from folks. Noelle, Elaine, Katie, Regina, you folks that do this?
I'll start. I'll say, first of all, wow, you clearly have spent some time with our report, the committee study time committee report, and I appreciate that. It's better than therapy to have that kind of validation that all that work wasn't in vain. You read the report, and you see the issues and you seem to understand them. And not that gets us to a solution necessarily, but man, it's a great first step. So thank you for the time you've clearly already spent on it. And and this task list is so thoughtful. So thank you for that.
And Katie, I'm going to interrupt you right there and say that, but for your study committee, it would not be so clear what the issue is. I mean, all of those hours were not in vain. Y'all had to really dig deep to figure out, what is the problem? What are the issues? And you went a lot further than that, but that took a lot of work and a lot of insight and a lot of discussion just to get to that. And so we're able to go, okay, here are the issues. So thank you for that. Go
Sure,
ahead.
thank you. I will say it's a challenge, and I know, perhaps off topic, but no, I don't know. It's not off topic. I'll say, we both at the commission level, at this committee level, this subcommittee, and at the study committee level, we get these really passionate members of the public who want to participate, and it's wonderful. But it can be hard to explain to them, and then hard to sort of refocus on, but it really makes the point that Judge Williford was just saying a minute ago. Every family is different, and your individual experience is valid as it is, but it really highlights how creating legislation or recommending legislation is so challenging, because legislation ends up applying statewide. And if you were writing legislation for one family at a time, frankly, it'd be easier to write the legislation, but of course that could never happen, because who has the manpower and resources to do that? I also agree with Judge Williford that the legitimation issue in Georgia and the very high percentage of children being born out of wedlock is a real factor in this, and makes it incredibly challenging to draft anything related to parenting time, because it will by definition affect those families and the others, but it affects those families, and those families don't have the same sort of rules of the road, if you will. So that's incredibly challenging. And then not for the first time, I would remind everybody that it's even if we broke Georgia's citizens into two categories and had child support legislation for those who are represented by counsel, and those who go through the DCSS, even that might make it easier, but that's not how legislation works. So the number of times that we've discussed something and it seemed, like we're headed towards a consensus or something feels obvious, and then somebody raises their hand and says, hang on, that won't work for our families, our many Georgia families that go through, DCSS to secure their child support. And it's like, oh, right, because it's the rules of the road are different. And so, we have to stop and adjust and think differently about how we're going to approach it, and how we can come up with a way to approach it that is in the best interests of all of Georgia's children, not just the ones who are, subject of litigation with lawyers versus pro se versus, DCSS cases. Those are really challenging. And I think the legitimation issue comes in that, in that vein, a good bit. In terms of who in the family law bar, or who in general can examine this legitimation question, issue, challenge, I can tell you the current chairman of the family law section of the State Bar of Georgia is Ted Ettram. He's a dear friend and a former colleague of mine. Well, I guess he's a colleague of mine, period, but we used to actually work at the same firm together. And I know for the last several years that the family law section has had an active legislative committee of their own that has, monitored legislation and addressed things, when they could. We can certainly ask him to ask, their legislative subcommittee to put it on their radar. But circling back to what I was saying a minute ago, that sometimes the buckets in terms of what perspective you're coming from are represented parties, pro se parties, and DCSS. Much of the family law section, just by definition, and being that it's made up of lawyers who openly say I practice family law, they tend to focus on that first bucket because that's what they do. So even they have to be reminded. So I think the family law section's a great place to start, but you remember that in doing that, that's an audience of people who practice family law day in and day out. They don't inherently, many of them don't just automatically think about the cases for pro se litigants and DCSS cases, because that's not what they do. And of course, the DCSS litigants don't have a lobby. We've got our Byrons and they're represented here in our committee and on the commission. And we make sure they're always included, and thank goodness, because I can't tell you the number of times we've had a conversation and one of them has, raised a hand and said, here's what you're not thinking about. But they don't have a lobbying group or, other than, the staff, professionals, like Byron. And I suppose people like Mara, also sort of indirectly represent that community of people, but it's not the same as having a family law section like the state bar has. So I think we can talk to them. We just have to be mindful that there's always that group that's sort of, seems to either be left off the radar or at least comes in kind of at the end saying, oh, here's the problem with what you're saying. So to the extent that we move further with that discussion, I would say we really need to get a couple of people who are really dedicated to making sure that the conversation doesn't go too far without considering that piece of the pie, because we've seen that a couple of times over the years in our discussions at for this committee. Of course, Judge Williford, you gave the perfect example of it. Is somebody comes up with a great idea like let's just build the parenting time question into the BCSO table, and then somebody says, well, that doesn't work for DCSS. So that's a perfect example of the kind of thing that can happen. I fully support further study and conversation. I think that as Regina said a little while ago, we spoke a long time ago about the difference between, a study committee at the commission level, which obviously we've done that long, hard work, versus a legislative study committee. And I like that idea. I've not participated in anything like that, even in all these years on the commission and on the statute review committee. I certainly think that could be helpful. So I guess likely would be helpful. And I think I will say I'm supportive of that because there just have been many times where even our legislation, our recommendations for legislative change have, once we turn them over to the legislators, and I realize we don't have any of them who are on our committee available today, but, at our study committee or at this level, and even at the commission level, we sometimes lose sight of the fact that once it's legislation, we don't have control over it, and we may or may not have influence over it. And we can end up with things like we have had before, where a child support bill that was intended to do some really just sort of rudimentary cleanup, pedestrian cleanup of the bill, ends up with some substantive changes tagged onto it, amendments added to our bill. And next thing you know, we're going, wait, that's not from us. Because we lose control over it once it's in the hands of the legislators. So I think for many reasons, that being one of them, that might be a good way to address all of these questions and concerns at the next level.
Well, just piggybacking off of what you just said, I have two thoughts. One, had I known as a family law attorney, and even now as a judge, that something as monumental as, okay, we're about to bring back potentially Schedule C, and we're about to have potentially a parenting time adjustment. Had I known that as a member of the family law section, I would have wanted to be involved in that, or know as much as I could about that, or figure out how we could do that the best way for practitioners, for litigants, for judges, depending on what angle I was coming from. And so I wonder if we or I or you or somebody doesn't maybe set up a conference with, you know, whoever's chairing the family law section this year, or whoever's chairing the statute, the legislative committee of the family law section, and say, hey, here's what we're working on. Here are the problems that we're running into. And ultimately, we see as a big problem in fixing this, what we think would be the best way to fix it is the fact that we have this group, this DCSS / non-legitimated fathers kind of group that's so different from this group over here. And so if you fix it for one, you mess it up for this one. If you fix it for this one, you mess it up for this one. And so, we need to get this fixed. The other thing would be, and again, they're not on here today, but the two senators who are on the Statute Review Subcommittee, and particularly maybe Senator Brian Strickland, who I think does practice family law with a family law firm in McDonough, and say, look, here's, really do a deep dive into what the issue is. And again, that this legitimation issue is such a huge issue that we can't fix the way it needs to be fixed. And we need somebody to pick up that ball and run with it and get that fixed in Georgia. We have these senators on our subcommittee, and maybe that would be the best way to start. Elaine, what is the percentage of folks who are born out of wedlock now in Georgia? Is it 45%?
It was 46%, according to the Department of Vital Records.
Yeah. So we're at, we're getting close to 50% of the children that are born in our state are born out of wedlock. And to have this, they don't have any right, they don't have a father legally, is asinine. I'm sorry. I mean, I'm not trying to get political here. I'm supposed to be completely nonpartisan, but that just doesn't work anymore. That just doesn't work anymore. And somebody has got to fix that, and I don't know how I can really appreciate, Katie, what y'all been up against for 4 years, because I was like, what do you mean there's no parenting time built into the BCSO? We got to fix that right away. And it was like, oh, but what about these folks that legally have no parenting time by law? Oh, so there goes that idea right out the window, So I think that we start maybe with the senators that are right here on our Statute Review Subcommittee. And if they can't move for us, then who do they know that can? Also discuss with the Family Law Section's Legislative Subcommittee about what we're working on, what we're trying to do, and the roadblocks that we're running into as a result of this legitimation statute. And then, as Regina said, decide at what point then and how you go about a legislative study committee. And maybe it's that, and again, I hate to say I'm so ignorant about how things work, but is that something, Regina, that Senator Brian Strickland could say? I think we need a legislative study committee on these issues.
So just like the commission can authorize Ms. Carter and Leg Council to draft a working draft of a statute change and a legislation change, we can also work on the language and authorize her to prepare the resolution that assists whoever you've identified as your Senate or House sponsor of the legislation in dropping that and getting that passed. So it's a similar, but most of the time easier process to get a study committee done than to get complex litigation passed, just in general terms. Same process, still has to be passed. A House study committee only has to be passed by the House. Senate study committee only has to be passed by the Senate. And a joint study committee, which are very rare, has to be passed by both chambers, just like legislation.
Yeah. And I guess the problem is when things are complex and people don't understand it, they don't put as much, I don't know. It's just harder. I agree. Because sometimes I just go, forget it. Let's just leave it the way it is. give the judges discretion, we'll figure it out. But the bottom line is the judges aren't figuring out. I do think it goes back to Regina. A lot of folks don't realize that there's no time built into that. And then if we do educate them on that and everybody starts deviating it, then our deviation rates have gone through the roof and we're in trouble with the feds. Ms. Block?
Yeah, hi, good morning. I just want to, sort of, I guess, express not necessarily a concern, but just to not be hasty about throwing the baby out with the bathwater on the legitimation issue. I know it's very antiquated. I practiced law in a different state, family law, before I moved to Georgia. It was shocking to me to learn that that was the state of the law here. But as someone who represents a lot of domestic violence survivors, I would encourage that we talk to the DV advocate community before we decide, that we want to get rid of that statute on legitimation or automatically grant rights to unmarried parents, second parents. I think there is a benefit to many of my clients who are survivors of domestic violence, and it can be empowering to them to know that they have some distance from their abuser. And so I don't know if I have an opinion yet about whether or not I think legitimation should continue or not in this state. And I think it's a little beyond the scope of the conversation for the child support statute study commission subcommittee. Certainly there is an intersection there that needs to be considered. But I'm not sure, it's something I would really need to think about. And I would want to talk to my colleagues and talk to other DV advocates about before, and maybe the broader community too, about what are the other implications of that beyond, sort of how it intersects with child support.
Oh, and I agree with you 100%. I actually, in addition to sitting on the Georgia Child Support Commission, I sit on the Family Violence Commission.
Mhm.
So there are so many, and as Elaine mentioned to me yesterday, the adoption advocates, there are so many different folks who are always going to have different perspectives and different opinions on what we should do. But as the Child Support Commission, and how to fix the child support issue, and the child support worksheet as it relates to parenting time, I believe that is certainly very relevant, not outside the scope of the conversation, that the non-legitimated folks and the folks that DCSS is servicing the majority of the time, that it is all intertwined and it is all a part of that picture in terms of how to fix the child support worksheet. What it means for, mothers of victims of domestic violence and folks who are trying to adopt and all that thing, it's going to be completely different issues for them. But the hat that I'm wearing right now as the chair of the Georgia Child Support Commission on the subcommittee regarding this parenting time study, I think it is definitely relevant. But if we have a study on it, then that's what's important, is we can be educated on all those things. Just like Katie's study on parenting time said, well, you hadn't thought about this. Oh, but you hadn't thought about this. But here's the problem with this. If we have a study on the legitimation statute, and I know there must have been one done years ago because we had an administrative legitimation that didn't work, but certainly that was many, many years ago. It seems like that was 2004 or something, if I recall. I don't remember when that administrative statute came up. But if we have a study on it, I can guarantee you that study will include, but this is going to mean for victims of domestic violence. This is what it's going to mean. This is how the adoption advocates feel about it, and all these other groups that we're probably not thinking about. All I'm just suggesting is that maybe there needs to be a legislative study, or somebody somewhere needs to be looking into that, because the way it's written now, I think is antiquated. I mean, and that's my opinion. I don't speak for everybody, but Certainly we're I think we're down to one of 2 states out of the 50 states.
Yeah, I think that's right too. I'd heard Georgia and Mississippi were the last
Yeah.
2 that did it
Who
this way.
actually deal with things that way. So maybe that's one red flag. But you know, that's an issue that I think we have to consider, is that, you know, we need to look at the study before we can think about all those things. 2 good issues that you just, or at least one good issue that you just brought up. I added the adoption issue, but if we don't have the study, we can't consider those things. But certainly I appreciate you mentioning that, because that is a group that will probably give pushback on that, is the Family Violence Commission.
I agree. And I have to say that was sort of my point in saying, you know, if we just look to the family law section, not that we shouldn't look to them, but we have to remember to get more than that, because their audience is different than, for example, Mara Block's audience. And so I think, you know, that's sort of my point, is that we don't, when we do it, if we do it, however we do it, we need to make sure that we're soliciting the input from all of the folks, so that we don't end up with a situation where we have a last minute, you know, hey, this doesn't work, or even just, you know, put in a bunch of work that turns out was all sort of for naught. So I agree completely. That said, you know, as a general rule, I think being down to, you know, one of only 2 states, you know, on that, especially in a trend that's where we're on the back end of the trend, is not generally a good thing. If we were one of only 2 states who have recently made a change, and, you know, and we're going forward and the other states are looking into it, that's the good end of a trend to be on. But it doesn't sound like we're on the right end of a trend, especially since, you know, we know that, you know, as of the last stats, and they're always a couple years behind, you know, what we know is that 46% of Georgia children were born out of wedlock. I mean, we can say logically it's probably higher than that now. You know, we wait for Vital Records to pull their records and give us numbers. So by definition, that number's, you know, it's out of date by the time we get it. But what we do know is that it's trending up. And so, you know, we're somewhere close to half of Georgia's children are being born, you know, out of wedlock. And you know, the reality is that the current state of our statutes, are not supporting those children in the way that they should be. You know, what should be done about it? Careful conversation, careful consideration from all sources, nothing knee jerk, nothing, you know, but that's where we are. And I think to Judge Williford's kind of overarching point is that issue may not feel like, you know, may not right off the bat feel germane to the, you know, the child support statute review subcommittee, but it is, because it's impacting our ability to make suggestions for the child support guidelines that are in the best interest of all of Georgia's children.
I think it's directly tied to it, because every time we try to come up with a solution, it's, oh, but what about DCSS, and what about I mean, it's so connected that it's almost one.
Right.
You know?
They're inextricably linked. There's just there's no way around it.
Yeah. Right. Any other comments?
I have a comment. This is Christina Scott. I agree with everything pretty much that you said. I think Judge Williford, you did a really great job on coming up with the task list. And it's interesting because it had a lot of things that I was looking at recently and reading through the report that the study committee did do such a great job on. And coming from this perspective of mediator, I am a professional mediator, been mediating for about 17 years, 14 of those years doing domestic mediation. And this is what I do full time. So I have mediated probably over 2,000 cases. And the parenting time deviation issue, you know, it has always been an issue. It has been increasingly becoming an issue. As you stated here, probably in the last few years, you're seeing a lot more families that are doing things that are closer to joint custody and parenting time. And then you're seeing the non-custodial or I like the term that the committee kind of tossed around, the lesser parent, you know, fighting for this time that they have to try to justify, because of the way the statute is written, and it's clear that they have this time, but because of the way that things are done, it's hard for them to, you know, have their position taken into account. So it needs to be a change. I think the idea on the resolution for the legislative study is a great idea. And I do agree that we need to look at all the different factors of people. As Katie mentioned, we've got the practitioners who have been doing this. You have the community, the violence community. I think too, you know, even as a mediator, perhaps even some more opinions of mediators to be shown, because there's some that I know that mentored me that have been mediating a lot longer and have other perspectives as well. Because a lot of times in mediation, especially when I first started out, I dealt with a lot of pro se parties. And so you see their perspective. I think we're right. We have to have something that is simple, that's not difficult. But there's so many factors to this, you know, trying to figure out what the time is going to be, what's going to be the standard of measure. So I think that you do need something that is going to be more streamlined, of someone that can, like you said, that can present something, whether it's Dr. Venor, and I don't know her, haven't had a chance to meet her, but some expert that can kind of help us sort of check off the boxes and know exactly what we are presenting. And I do agree as well that the legitimation statute is very closely tied to this issue. So it's sort of one thing, and it's hard to talk about one without talking about the other. And perhaps the legislative study that can help us to sort of streamline everything.
Thank you, Ms. Scott. And I appreciate that you brought up the issue of the terminology. I don't like custodial parent, non-custodial parent. I hate lesser parent. I'll be honest with you. Nobody wants to feel like they're a lesser parent. Nobody wants to feel like they're a non-custodial parent. I don't know what the right terminology is. As a practitioner, I tried to use primary custodian and secondary custodian. I thought that was, even though again, secondary seems to mean lesser, it didn't seem as offensive to me as lesser or non. But words are important and terminology is important. And I think that's something that the statute review committee needs to be thinking about too, is what terminology we need to change overall in our child support statute. You know, years and years ago, I stopped using the word visitation. I only use parenting time, and I tried to use primary and secondary when I referred to custody. But terminology is, and Katie hinted on this a little bit too, is sort of outside of the scope or other things that came up, but terminology is another thing that I think we need to be looking at for the Georgia Child Support Commission. And if we're going to do a legislative study committee, I think the terminology is something that we also need to be considering. But in terms of, again, my scope is the parent, the co-chair regarding the parenting time study. In summary, unless somebody else has something to say, I'll just say we're not ready yet to recommend anything to the legislature. We need to either get a legislative study committee going and get some more information, or we need to get Dr. Jane Venor going, or both, before we're at the point where we need to be recommending something. And it's important work that needs to be done and probably should have been done years ago. So I hate to delay it any further, but we've got to do it right. If we don't do it right, we might as well not do it at all. But I do think that the study committee, who worked so diligently for 4 years, consensus is it needs to be done. It has to be done. It needs to be an adjustment and not a deviation. And we've just got to figure out what is the best way to do it. It's got to be simple enough for folks to use, but yet fair to all and in the best interest of children. And I'm not even trying to say that I've got it figured out, because I don't. But every idea that I have to try to figure it out is roadblocked by the fact that we do have these two subsets of people. We have legitimated and we have non-legitimated. And so I would like to start by maybe making an appointment to speak with at least the senators on our subcommittee, and maybe whoever the current president is of the family law section, and whoever he thinks ought to be part of that conversation. Maybe set up a Zoom meeting with those folks, and maybe Noelle and Elaine or whoever else wants to join us, to just sort of tell them what we're working on and what we're thinking about, and also to have Elaine and Noelle and LaTonya to find out if this is something Dr. Venor could help us with, what we would be looking at ballpark in terms of funding, and whether or not the commission has any money in the budget that we could pull from to help us work on that. And all of that, again, depending on what Dr. Venor has already done and what her recommendations are under our current contract with her, those two broad things, number 14 and number 15, that we talked about, that's in her current contract with us, what the responses are to those questions. Anybody else on that topic before we move on to the next thing on our agenda?
Judge Williford, I love that idea. I actually have to speak to Ted Etram, the current chair of the family law section, later today. Anyway, unrelated to anything we've discussed today. So I can certainly ask him to, and then follow up, email copy to everybody, but, and, ask him to think about who he would want on that introductory call. And, if he would, anyway, I can start facilitating that as early as today.
Let's at least fill the family law section in on what we're working on. I
also really like the idea of connecting with Brian Strickland. I've actually I've had cases against Brian, and in the land where things are strange. Brian's mother and my father-in-law are first cousins. They don't really know each other that well anymore. But Brian has a son named Beecher, and I have a son named Beecher, named after the same great grandfather that neither one of us ever met. So yeah, isn't that funny? Just strange.
Well, I don't know Brian personally, but I'm familiar with the firm that he works for, and I certainly have tried cases against partners in that firm. And so not to take anything away from Senator Emanuel Jones, who needs to be part of the conversation as well, but I do know that that firm is very well versed in family law issues and involved heavily in the family law section and the family law bar. So I do think we ought to start by reaching out to the legislative subcommittee of the family law section and these senators and Mr. Cuthbert or anybody who needs to be involved from DCSS, so that we make sure that they're part of the conversation at all times too. And again, let's see what Dr. Venor says. All this may change based on what she says, and let's find out if we can continue to contract with her to help us on this issue, if she's willing to, and if we have the funding for it. And then let's just report back and go from there.
Okay, and also for clarification, are we raising yet to the full commission? Because right now we don't have quorum for this subcommittee, but regardless, no action of a subcommittee is binding on the commission. So they have to prove anything. So we could also directly take up at the commission level, proposing a resolution for a legislative study committee. So are we going to do that next Friday, or are we going to hold off on that until September 30th?
Let's see what Dr. Venor's report says would be my recommendation. And let's have these conversations with some other folks so we know more about what to recommend to the commission. I think it definitely needs to happen, the legislative study committee. I just have a question in my mind about where in the timeline we approach it. And so I don't think it would hurt to get some more information and see what Dr. Venor's initial report looks like, and have some more concrete ideas before we present it to the full commission. That's just my thinking.
Okay, yeah, I don't have an opinion on it. I mean, I would just ask Regina Quick or our legislative council their thoughts on that. Do we have a little time to wait? Do we wait till like the September 30th commission meeting to discuss it?
Regina, where would we, at what point, I mean, the legislative session is not in, but how does this get started? Who do we contact? What would the timeline look like? If we contacted somebody right now, would they just say, we're not even open for business for that? Or what would that look like?
Well, so the real answer is that there's plenty of time,
Mhm.
and especially if we write it, because a legislator is, going to want your ideas, but also if it comes sort of prepackaged as a concept with the language and the recitals and the composition of the study committee, and that's not a significant amount of work that takes them away from their legislative agenda, since this is just a study committee, you got all the time in the world, but I would say have it ready before January.
Okay. All right, well, I say we look at what Dr. Fenore's report is and make some of these phone calls and have some of these conversations so that we're more well-versed in the process and the procedures and the needs, and then present it further. I mean, we can certainly let the commission know what we're talking about and what we're working on, but in terms of actually moving for some sort of legislative study committee, I'm not sure we're quite ready for that, but I do think it needs to happen.
I agree completely. At this point, shall we move to the next agenda item?
I think so.
Okay.
Unless somebody else has something further to add.
Right.
Katie, I do want to add something very quickly. I have been communicating with some of the other statute review members to try to find out if any of them could join us. Judge Key is not available. Senator Strickland is not available. And I also heard from Judge Colbert, and she's on the bench in a trial. So I don't think we're going to get our quorum today. And I just wanted to share that information.
Thank you. And I think, did we hear from Judge Petty that she was in trial today?
She's supposed to join us when she can, yes.
Okay, I'll ping her and see if she's able to join us, if for nothing else, maybe to pass our minutes.
And Judge Key also told me if necessary, he could jump out of what he's doing and come into this meeting just for the sole purpose of handling the minutes, the vote on the minutes. So if we can get 2 members, then I can ask him to join us as well, just for that few minutes.
But doesn't there need to be a quorum for the commission members? Because Judge Petty is a non-commission member, or does she count as a vote on that?
She's a voting member of this subcommittee.
Okay.
Right.
All right. Perfect.
Also, I'm not completely convinced that we necessarily need 2 more. I think 8 folks on the subcommittee would give us a quorum, and Pat can just abstain on voting.
I agree, actually. I agree.
Well, do we have 6 members?
We have 7, I believe.
Well, that would include Pat.
Yes,
Okay, so
we need 8.
we need 8 for quorum.
Right.
So if we could get Judge Key or Judge Petty to join us, we would meet that quorum, is what you're saying.
Yes, and that would be
Okay.
delightful.
Yes.
Yes.
So Katie, if you'll let me know about Judge Petty, if she cannot or
She's
can't.
writing me back now. Let me see
Good.
what she says.
Okay. And if she can't, then I can go back to Judge Key and ask for his limited participation.
She said she's in a hearing, but she could take a quick break and do it. She said, just give me a minute. Okay, so I'll tell her that would be awesome. I'll tell her we'll make it fast and be back to her hearing. Okay. Okay. while we wait for her to log in, and when she does, we'll circle back to the minutes. But until then, we'll go ahead and move on to our next agenda item, which is consider extraordinary expenses handled outside of the calculator. Hopefully everyone recalls that this conversation has taken place a couple of times, including at our last meeting when Ms. Quick brought up the potential to explore the 7% threshold, which may create reversible error if a judge divides extracurricular activities without first considering the 7% threshold, and indicated there may be a couple of appellate cases on point, and I believe that there are, and she has communicated that to us. And if I'm not mistaken, while I do not have it memorized, I know that was a regular conversation during the Parenting Time Deviation Study Committee work, and was on the list of issues from that committee as hey, just, not in our purview, but something y'all should consider at the commission level, that this continues to be an issue. And I know Mark, God rest his soul, that was an issue that was, he was passionate about as an economist and somebody who was looking at the overall fairness of our child support guidelines. So I will open it up to discussion at this point. Does anybody have strong feelings? I know, Elaine, I think you might have some information for us on that. We could start with that if that's okay.
Oh, yes. Okay. So one of the things I did regarding the extraordinary expenses, special expenses for children, is that I contacted Dr. Venor because there had been a good bit of conversation about the 7% test for special expenses for child rearing. And she has made me aware that we in Tennessee, Georgia and Tennessee, are the only two states that included that provision in its statute. And we actually brought that over from the Tennessee statute, which we originally started working with, copied back in 2005 when all that work started, or maybe 2004 even. But Tennessee uses that. Now, Dr. Venor also indicated that the percentage has now gone from 7% to 6%. So if Georgia does choose to continue to allow this calculation within the deviation, then that amount would need to be changed, but she was going to confirm that for me. I don't have that confirmation yet. She also told me that that's optional. States don't have to include the 7% test. It's simply an amount. It's not included in the BCSO table. So it's considered, the expenses like this are considered optional, but also they're looking at just those extracurriculars. Your band, your softball cost, football, baseball, dance, those types of things. So it's optional. We don't have to have it in our statute, and Georgia can make that decision. But if we do decide to keep it, we would need to possibly change it to 6%.
I'm sorry, I'm going to interrupt you right there and say, I believe Judge Petty has joined. Can we move her?
Yeah, she's in.
I just did.
She's here.
Sorry, I'm in.
Thank you, Judge
Hi,
Petty.
thank you so much. Don't apologize. We know you are busy and in the middle of a hearing. Thank you so much for jumping out of that. Without further ado, we'd like to entertain a motion to approve the July 15th minutes. Judge Petty, to update you, there were no proposed revisions. So if someone will make a motion to approve them as drafted and distributed.
So moved.
Thank you. And we don't think we have to have a second. Can we get a vote on that? And I'll rely on Latana and Elaine to count the vote, but can everybody vote? I'll say approving votes. Okay, any nays? Okay, and any abstentions? There we have it. Okay, so the July 15th minutes are approved. Thank you very much. Judge Petty, please feel free to stay, but also please feel free to go back to your hearing. No worries. This was very helpful. Thank you very much.
You're very welcome. Thank y'all.
Okay, so back to it. Elaine, so you're saying that the percentage, among other things to consider, the percentage is moving from 7% to 6%. Is that something, just pardon my ignorance, but is that something that you're anticipating being included in Dr. Venor's 2022 report that we just haven't seen yet?
She may address that in there because she knows, because I sent her the email asking the question and that this was of concern. And so she may very well put it in the report. I don't know. I haven't seen anything preliminary yet. But when she speaks to us next Friday to the commission, then certainly that could be a question that we ask her. I can even ask her in an email to make sure she covers that with us. But she made it clear to me, she does not recommend to states that they must have this particular calculation included. It is for the state to decide, do you want to include it or not?
Okay. And Georgia has opted historically to include it.
Right, which came from the Tennessee
Right.
statute that was passed the year before ours, which we copied and worked from originally.
Okay.
We started out by mimicking Tennessee. Tennessee did it, and so we did it.
Mhm.
And all these years later, Tennessee is the only other state that's still doing it.
That's correct.
And we know that almost nobody does it that way. Everybody sort of figures out what extracurricular is going to be without considering the 7%, especially self-represented litigants and people that don't even know that 7% is in there. So
once
I think
again, we are in that minority spot, but not on the front end of a trend, but on the back end of a trend.
it needs to go. It's my opinion.
And I think Pat has a question.
I just wanted to know if the portion of the meeting that Dr. Venor is reporting in next week will be recorded, or will be able
yes.
to listen in?
Yes, it will be. We always record these meetings, so it will be recorded.
Okay. Can you
Yes.
make that available to this subcommittee?
Oh, absolutely.
Okay, that would be very helpful.
And she's going to have a PowerPoint that we'll also be able to present to you.
Okay.
That's a great thought, Pat. Good idea for those on this committee who aren't able to attend the commission meeting.
Noelle, just as a point of clarification, now that we once had a quorum, if a motion were to be made, do we need Judge Petty or Judge Key back in the Brady Bunch screen to do that?
I think so, yeah, because we've just lost quorum for voting.
I'm sorry, Regina. I should have asked if anybody had anything else while we had Judge Petty. I just was trying to get her on and off. I apologize.
Oh, no, that's okay. I just didn't know if we were going to try to take action on this agenda item, which sounds like there might be consensus on here.
It does sound like that. Let me ask it the other way then. Does anyone have an objection, or would anyone like to have discussion about not doing away with our percentage threshold, 7% going to 6%? Does anybody have any thoughts or feelings on that?
Katie, I just want to say that I'm familiar enough with this issue that I do think I could vote on it. So if that helps with the quorum issue.
I don't know. I'll rely on Noelle and to tell us where we stand on that front. Thank you, Pat.
Now we're just down to 7 people and we need 8 for quorum. But I'm even unclear as to exactly what the motion would be for. What are we talking about? Just reducing it from 7 to 6 or taking that out of the statute altogether?
My motion would be that this subcommittee recommend to the full commission that the statute be revised to eliminate that threshold and allow extracurricular expenses to be handled outside of the worksheet.
And allow but not require, is that your thought?
Yes.
In other words, they could be built in but don't have to be.
Correct.
Which I think I think the discussion from the July 15th meeting sort of included that that's what many people are doing anyway.
Okay.
Reversibly so, but yes.
Correct. Yeah, right. I didn't say they're doing it well or correctly. I just, that's what they're doing.
And
okay.
I guess I have a question on that, Katie, if that would still, because this is a deviation, all 3 of these expenses, this would still be discretionary?
That would be my reading of it, because my understanding of the statute as a whole is that everything that falls in the category of deviation is discretionary. And that's why we're hopefully careful to use the phrase adjustment versus deviation, knowing that those for our purposes are terms of art, and adjustments are, required to at least be examined, if not made, and deviations are not required to be considered or made. It's up to the trier of fact.
Okay, thank you.
If it's handled outside the worksheet, it's neither.
Correct.
And does there need to be a consideration of whether or not it needs to just be handled outside the worksheet, period? I mean, what is the purpose of keeping it as even an optional Schedule E deviation? Just give the practitioners and the judges the option of including it on Schedule E rather than addressing extracurriculars separately?
It's separate from child support. Could it be paid through
Right.
an income withholding order or income deduction order? Is that the issue?
Correct. That's the issue, Mara, and that's without it being a part of the child support calculation, it could not be included, is my understanding. I'm not an IDO expert, but that's my understanding of income deduction orders. So I think that the
Option, that's the reason for the option then.
correct, not, and I mean, I've seen cases where judges have found that the conflict between the parents is so great that minimizing even the back and forth about reimbursable expenses has been found to be in the child's best interest, including extracurricular activities. So going ahead and building in a threshold, threshold amounts based on the child's then existing activities and whatever evidence is presented to the judge so that the monthly amount covers it, and there's not a lot of back and forth about whether the child missed a math tutoring. Well, I guess we're talking about enrichment activities at this point, but whether they switched from band to soccer, and maybe the price difference. I think the courts, in my experience, have liked having the option of putting it in the worksheets to avoid further conflict. And then when they take it out of the worksheets, to Regina's point, they're doing it now anyway, even if it is reversible error. So we might save a trial court judge a headache or two with a potential appeal when, because there's always that somebody who figures out it wasn't being done well or correctly. Okay, so we don't have quorum for the vote. Can we, for purposes of, since we do have meetings on our already scheduled, and that's our last agenda item, and I don't mean to jump ahead, but can we maybe articulate the motion in such a way that it could be put on the next agenda? Open it up for maybe some brief additional discussion in case anyone has it, but go ahead and get the motion on the next agenda and see if we can't sort of rally the troops and ensure that we have quorum, knowing that we're definitely going to have a substantive agenda item to vote on, a motion to vote on. How does that sound, everybody?
That sounds great. Let's try to get it on the agenda for the next meeting.
Okay. Okay, so I will rely on staff to utilize the minutes from this meeting to articulate the motion in a way that it can be on the next agenda. And if there are questions about exactly how the motion should be drafted, you can always shoot me an email and we can make sure it's on the agenda correctly. And either way, we'll have, discussion, and everybody will have the option to vote at our next meeting. Does that work?
Yes.
When is the next meeting?
Well, that's last on the agenda, Pat, but they are scheduled, and the next meeting is scheduled for September 22nd and then October 21st. We have 2 meetings on the calendar. Okay, before we get there, next on our agenda is we have lots of different ways to say this, House Bill 481, the Life Act. But basically we've got definition of a child under 19615A1. And I will turn it over to Noelle. And just as a reminder, this is a continuation of the conversation that we had at our July 15th meeting. So Noelle, if you will start by updating us on
Okay, thanks.
Pat, you're not on mute.
updating us.
Oh, sorry.
It's okay.
Absolutely.
I think there have been changes, in case you have been under a rock and haven't seen any local or state news. There have been changes since our July 15th meeting with the 11th Circuit. So if Noelle, if you'll start with that.
Sure thing. So as you were saying, at our last meeting back on July 15th, I reported on the status of the Life Act, which at that time was stayed by order of the 11th Circuit in the Sister Song case. So you asked me to keep it on my radar, which I have. And back on July 20th, the 11th Circuit entered an order lifting the stay on the Life Act. Now, as it pertains to us, the Life Act amends our child support guidelines in two ways. First, it changes the definition of the term child in our statute to include an unborn child with a detectable human heartbeat. And then secondly, it creates a new type of child support specifically for unborn children. And child support for unborn children is very different from the child support that we're all familiar with once kids are born, because typically our typical child support for children after they are born are prospective, meaning it's set and it's paid going forward. It's largely based on generalized economic data, we call it the BCSO table, and may obligate either a mother or a father, depending on the circumstances of the family. That's why we speak of custodial and non-custodial parents. We don't speak of mother and father any longer. Whereas the child support for an unborn child is retrospective, exclusively based on actual expenses, and appears to create a reimbursement scenario in which literally the quote father specifically reimburses the mother of the unborn child. So the Life Act is beautifully brief. It's amazingly brief, but it also mentions that after birth, the provisions of this code section, meaning OCGA 19615, shall apply in full. So I take that to mean that the General Assembly did not intend to change the way we set child support once the child is born whatsoever. And I conclude that these two types of child support could be ordered at the same time, but otherwise they don't affect each other and are completely different things. So really my report today is completely advisory. I want to make you aware how OCGA 19615 has been affected by the Life Act. I want to also mention, and we have Byron Cuthbert from DCSS on the line with us, but I have conferred with our colleagues at DCSS, and at the moment, at least, they don't have any concerns at this time that they've shared with us. I've also confirmed that they have not received any directives from federal regulators on this topic. We did receive an inquiry from a Mr. Kroll, who is a Deputy Chief of Staff at DHS, and he just generally inquired through Chair Judge Key, what plans or work does the commission have in regard to the Life Act? So Elaine and I crafted a response at Judge Key's direction, offering basically what I just explained to you, that at the moment we see them as very different things and really unrelated to each other, although I suppose they could be ordered at the same time. And I offered to speak with him. We offered to have him on this agenda if he'd like, but we did not hear any response from that gentleman since his initial inquiry. So those are my observations. The only thing else that jumped out at me is I know a few years ago, the commission worked hard and felt that it was important to make our statute gender neutral. So there was a concerted effort, and in fact, legislation to remove the words mother and father from the statute. I was like, oh, that's interesting. Now it's back in there. But it's really only back in there in that one instance as related to what I've in the past called gestational child support, for lack of calling it anything else. You know, that jumped out of me, but it's different in every way. So it also isn't different in that way. Maybe we just leave it be. So I just wanted to call this to your attention. I'm not advocating for any change necessarily. I do think there could be some wisdom in letting it be. It's very newly enacted. See how it plays out in our courts, see what judges are dealing with, see what happens when this is when this goes through our court system and is actually litigated. The other issue is I did just read in the paper 2 days ago that litigation is now pending in state courts, and it's before Judge McBurney in Fulton County Superior, as they just had oral argument 2 days ago on the possibility of staying the Life Act now up under litigation in our Georgia state courts. So there remains a possibility that this could get stayed again. Okay. That's all I wanted to say. Oh,
Sorry, start
Yeah.
talking, I'm muted. Okay, do we have any discussion, thoughts, feelings, gut reaction?
I think it seems like a bit of a can of worms to wade in at this time, but I think I mean, I think there will be litigation related to the fact that it only addresses fathers. And, you know, it doesn't contemplate artificial insemination situations. It doesn't contemplate same-sex parents. So I'm not sure, you know, I guess that's all I had to say. Sorry.
No, I agree with you, Mara. I think the fact that it doesn't consider those things has potential to be problematic at some point. I also think it's potentially problematic that it sort of creates a new category of child support that is addressed inconsistently with the rest of Georgia child support public policy. You know, just the underlying concept of our child support guidelines being, you know, that it's an income sharing model. You know, and this doesn't consider that at all, or at least not as I read it, I think is potentially problematic. Not that I know what to do about it. I'm just suggesting that has a potential for problem. Any other comments, questions? For those of you who have been around practicing in the child support arena long enough, long before our current guidelines, there is some case law, there is some old case law that sort of similarly provides for expense reimbursement. You know, it's not limited to pre-birth, but includes pre-birth expenses, at least as I recall those cases. And those cases at least provide some guidance in terms of what type of evidence is required. But they don't, you know, they were written long before our income sharing model. So it's, you know, they're very different. You know, but they do at least provide some, and they haven't been, to my knowledge, and I'll actually ask Regina to tell me if I'm remembering this correctly. I don't think any of those cases has been expressly overturned or in any way ruled, you know, to be inapplicable to Georgia law.
Those are still good law, I believe, and I think the judges that I've presented to in the past have felt bound to utilize that separate method in the you know, out of wedlock child situation.
Yes, that's, yeah, I think that's what we have, you know, whether it's, you know, I'm not commenting right now whether it's right, wrong, or otherwise, it's what we've got. So I guess the question for us is whether, as a statute review committee, we, you know, look at this new piece of our child support statute and consider whether it needs any tweaks or changes for any reason, whether it's to, I don't know, throw it out, make it more consistent with something, make it less consistent, flesh it out a little bit more. I mean, you know, do we have any interest in looking at that? And I will tell you my gut reaction to it at this point is that it feels a little half-baked and doesn't provide a lot of guidance. On the other hand, I'm not sure that it's not just because it's so new that it's hard to even, other than just brainstorming, it's hard to know exactly what the problems are going to be. I mean, we've already named a couple of potential problems, but, you know, we don't really know. I would say I wouldn't object to, though I'm certainly welcome to other suggestions, but I wouldn't object to the notion of just asking that this question be put on the agenda for the commission to consider, you know, rather than us sending it up. Let's see if they want to have a discussion on it and send it down. I mean, I say that knowing I'm a member of the commission, and so are several of you. So it's not, and I'm not trying to, you know, play hot potato with the issue, but it, it's also an issue that can be, as you all know, has the potential to be inflammatory, even if that's not anyone's intentions. So just being mindful that this can be a, hot button issue. I would be interested in seeing if the commission has any thoughts on it, and whether they'd like us to examine it further before we do. Not that we necessarily need their permission to consider an issue. That's, I don't know. I feel like issues go like this between our committee and the full commission. And I think on this one, I'd like to see what they have to say before we spend a lot more time discussing it. That's my suggestion, but I am absolutely open to alternative suggestions.
Yeah, I agree with that, Katie. I think the full commission should look at it. I think also, I'm trying to understand what Noelle said concerning that it's going to create a child support for unborn children. So another category of child support. Is that actually going to be part of 19615, or was she saying it's going to be another statute?
It'll be
It's
in
part of this.
15.
It's in
Okay.
there right now. So, and it's
Got it.
all addressed under the terms. There's now an section A1 of the statute, I think.
Yeah, it's located
Okay.
immediately below definition 25 in subsection A. If you look at the statute, that's where it's located.
Okay.
It's very new to the statute. For example, my annotated hard copy that I do every few, I like to think I do it every few months. Really, it ends up being about once a year. It's not in there because I prepared that annotated copy just, a couple months ago, and it wasn't in there yet.
Right. And I just
Oh.
shared my screen. I mean, this is the long and the short of it. This is all it says. When I said it's beautifully brief, I don't think I was exaggerating, but it's really scant, but, and I'm calling it a different type of child support because I don't know. I mean, there would be no way of including this on the child support worksheet or anything like that.
Okay.
It's talking about the maximum amount of child support. Here, I'm writing from here, which the court may impose on the father of the unborn child under this code section shall be the amount of direct medical and pregnancy related expenses of the mother of the unborn child. Obviously, it could be less than the full amount, but that's the maximum amount, what some people call birthing expenses. And then it just says after birth, the provisions of this code section shall apply in full. So for me, there's now two different types of child support: before, when the child's unborn, and then when the child's born.
Mhm.
And I think that it is a little vague as to what direct medical
vague.
and pregnancy related expenses of the mother are. And, I don't think it gives a lot of guidance to judges. If I were an advocate on behalf of the mother, I'd be asking for maternity clothes and, really anything that you could make a direct link to. And if was that the intention of the legislature or not, isn't clear. And, I haven't read the legislative history to know what they were trying to get at there, but direct medical and pregnancy related expenses is very, very broad.
And not further defined, except circling back on what I was saying earlier, there is some old case law that addresses, this concept that was in place before our current guidelines were in place. But as I confirmed with Regina a moment ago, is still good law. And I believe it's been a while since I've read that case law, but I believe it does, at least on sort of a case-by-case basis, go through some examples of what constituted direct expenses and what didn't. I'm pretty sure. And I think it addressed some of the evidentiary stuff in terms of what was able to be proved and not. But again, I haven't read that case law in a long time, so I'm not trying to give anybody a CLE on that case law, but I know it exists, and I believe it provides some guidance that may be applicable to this new, A1, in terms of defining those terms. But, I look at this, and not only do I have some, that sort of issue spotting from, back to first year of law school, the issue spotting of, fathers listed in there, and we kind of moved away and we're using gender neutral terms. I also noticed there's no mention of paternity and establishing, the actual paternity of the child. Maybe that is covered by the paternity statute, but I just think there are lots of, potential for issues.
Definitely potential for issues. I agree. Noelle, did they also, because they have, with the change here, does the change also apply to 19749 and 19750, which deals with the medical expenses and birthing expenses for pregnancy? Did they also like make some revisions on those as well?
You know, I could look at, I mean, I have the act as passed. I, of course, only honed in on how it affected the child support guidelines.
Yeah.
But which code sections are you asking? I mean, it affects lots and lots of code sections.
Yeah.
This is just a tiny little sliver.
Right,
of it.
19749 and 19750.
I'd have to go through.
I also have the act as passed in front of me, and just my quick review doesn't show that it mentions those. I mean, it mentions 197, but 197.1 and talking about parental powers. It's not. I don't think it addresses those two code sections. We can double check, but I don't think it does.
Okay.
Okay, so circling back and just being mindful of our time and our agenda. I feel like I got a little bit of support out of the notion of, asking the commission to look at, to consider, to what extent we want to look at this. I would say, if nothing else, whomever is discussing this in any great detail, we probably do need to pull those cases that address address the reimbursement type of version of child support. To see where that leaves us, because of course, as we know in Georgia, our statutes are not our only form of law. And there is, good Georgia law, and I don't mean good as in like quality of work, although I think it's probably fine, but as in like enforceable, existing, not having been overturned, must be considered law that addresses this type of question. So my suggestion is that we ask that it be this issue we put on the Child Support Commission agenda.
Okay, Kitty, at this point, that's been set because the meeting is
Okay.
next Friday,
Yeah,
but I
For
think
the
there's
19th, yeah.
I think there's room for that up under your report of this committee that
Sure.
Yes.
Sure.
look,
We can-
I can give this same report that I just gave to you to them if you think that's clear enough. I also think it may be helpful that I pull up that statute again and show them. I mean, those two little things are the entire amendments. So do you want me to make a similar report?
Yes, I think so. And we just got a comment from the public that I think is interesting. Another issue spotting type of comment from a Mandy Lee. Another issue to consider is the provisions of this code section shall apply in full may also implicate that the parent would need to go through a child support modification action in order to receive child support after birth. I guess depending on the timeline of the support in the gestational period, I think that's true. I think that's a fair point that could necessitate that. I will say that the court system would be moving faster than my experience says it is doing these days. That a case would be brought and resolved to final order during a gestational period and not still open. But it's certainly possible. Definitely yet another issue to be considered. I agree with that. Thank you for that comment. Okay, so I think we'll move on from that agenda item, and I agree with you, Noelle. We can just I'll make it a part of my report to the commission, and I'll have Noelle, you can do the initial update, and I'll sort of expound on why it's a part of my report for the commission. Next item, we've got new business, moving on to new business. Determining non-custodial parent in cases of 50-50 joint physical custody. And my agenda notes here say that staff is going to present on this issue. So who am I turning it over to?
I'm just going to make a quick suggestion, given the amount of time. I'm thinking we maybe hold this over. It's opening up a whole nother kettle of fish, and it's important that our members, 2 people have just had to already drop off. I think maybe we just move this to the September agenda.
Yeah, I agree.
Works for me.
I agree.
Okay, busy Friday. Let's just move that to the next agenda. So before we adjourn, as was stated earlier, just a reminder to everybody, our next 2 meetings are currently scheduled, September 28th 22nd and October 21st, both starting at 10 a.m. There was a question about identifying November and December dates. I would just ask staff that maybe you coordinate with Judge Williford's office and my office before we announce potential November and December dates, since we know that we sometimes have issues there and we don't want to set a date and find out that Judge Williford is, you know, in the middle of a lengthy criminal trial that she can't get out of, or that I've been compelled to attend a hearing. Because I have had one judge tell me that a child support commission related meeting was not a reason to move a hearing. So,
Well,
Okay,
I will say that when I took on this role, I made it very clear that my year was insane and that it was booked up every single day. And we've had to shift some things around just to allow me to be involved as I've been involved so far. And I do think that we're on the crux of very, very important work, and would hate to miss a meeting. So I will try to move heaven and earth to accommodate, but yes, definitely let's make sure that we look closely at the calendars and coordinate that. So I'd hate to just throw a date out there now without talking to my staff and looking further at my calendar. I'm sorry I missed that was on the agenda.
no, it's fine.
Well,
I think that's the right way to handle it, Judge Williford. That's why I
Yes.
said it. We need to accommodate your schedule first and foremost. So I agree completely.
Yeah. And I'll contact Jessica and Melissa, Judge Williford, and look at maybe just a November date at this point and see if we can, you know, come up with something that would work.
Yeah, I'll tell her to make it happen. She tends to have a breakdown when she has to rearrange things.
Well, she and I will get to know each other just as Jessica and I have gotten to know each other.
I'm sure.
Yes.
All right. Do we have any other questions or comments, or can we adjourn? All right. Have a nice weekend, everyone. We are adjourning. It is, my clock says 11:39. So thanks for your time. Everybody have a wonderful and safe weekend.
All right. Thank you all. Thank
Thank
you
you,
all.
Recording
everyone.
stopped.
To ramble.